Welcome back, everyone. Attorney Craig Steger here, practicing in Wisconsin, Minnesota, and Iowa. So today I want to talk about a very significant jury verdict that came out in Iowa last year. It was a $35 million verdict from a trucking accident case in eastern Iowa. I want to talk a little bit about it. There's a lot of interesting features of that case that might be telling for future cases, future trials of this sort. So let me start by showing you a picture because the picture I think says a lot about what's going on here. So this is a picture taken. I'm not sure if she's in the vehicle or not, but basically an 18-year-old young woman was driving on Highway 151, I think near Anamosa, Iowa. And as you can kind of tell, it was during the day, but it was pretty foggy. And that was sort of the gist of the plaintiff's case was that because it was so foggy, this trucking company based out of Cedar Rapids shouldn't have been on the road at all. And as I understand it, based on what I can review, this is a 65-mile-per-hour zone here. And the trucker was trying to make a left-hand turn, which is one of the most dangerous maneuvers a trucker can make, a left-handed turn across traffic, especially when that traffic has a 65 mile per hour speed limit. So the trucker turned left in front of this young woman, and she obviously didn't see the truck in time, and she slid under or hit the side of the trailer. Now I can't tell for sure which side of the trailer that she hit, but it appears to me this was towards the rear of the trailer, and that the tractor would have been to the right of this. That appears to be from the case. So she just missed hitting the rear axles, and as you can see, her car slid under the side of the trailer and caused significant head and facial injuries. I think they indicated she had like 100 fractures in her face. She was lucky to survive at all, but she sustained a very serious injury in this case. And there was a few things about this that are I thought were particularly interesting that I wanted to talk about. Um, I've done a number of videos recently on the so-called Mansfield bars, or the DOT bars, as they're sometimes called, which is sort of that bumper plate on the back of semi trailers, which is designed to keep cars that rear end the semi, from going under the back of the trailer. For this very reason, is that the floor and the trailer is sort of right at head height, and if cars hit that, um, it has a history of causing significant damage. That's the famous, I think it's Jane Mansfield is the name behind the Mansfield bars. She was killed in a crash back in the 60s, and that was one of the reasons why they required Mansfield bars on the back of semis. But that type of protection isn't actually required under the current rules for the sides of trailers, although I think it is in the European Union, if I understand correctly. But I'll talk about that a little bit because that was one of the issues in the case, one of the claims the plaintiffs made in this case. So the gist of the case was the argument, basically, as I understand it, the semi, when he turned left, could not see this young woman coming because of the fog. And so the question is, well, if you can't see far enough, should you have turned at all? And the plaintiffs argued that he shouldn't have been turning at all because he obviously couldn't see if there was anyone coming. So, interestingly, I kind of went back and I looked at some of the pleadings on this case, and there was originally a claim brought against the trailer manufacturer for that very reason, alleging the plaintiffs contended that these trailers should be equipped with this. I forget the name of it. I'll put it in the description below. But basically, side protection to prevent underrides when someone hits the side of a trailer, in addition to what they have on the rear. And so the trailer manufacturer was originally brought into the action. I did notice that they filed what's called a summary judgment motion, which they tried to get out of the case. And it looks like from the pleadings that there was a resolution reached between the plaintiffs and the trucking company before the court ruled on that. from what I can. There was also a claim for punitive damages that the plaintiffs brought against the trucking company. That claim was dismissed prior to trial. The trucking company brought a motion for summary judgment to have those dismissed, and the court agreed. So there was no punitive damage. This was purely what we call compensatory damages. Now, there was a few interesting pieces of information about this. Number one is apparently there was evidence that she did not have her seatbelt on when this happened. Now, not wearing a seatbelt can be considered comparative fault. It can actually reduce your damages, but it's an affirmative defense, which means that the defense has to be able to prove that if they'd had the seatbelt on, their injuries would have been less, right? And I believe that the rules limit the reduction of damages, I think, by 25%, if I recall correctly, for non-seatbelt usage. In this case, the defendants did not try to argue at trial um, that her failure to wear a seatbelt made a difference. And judging from the type of crash that had happened, it probably wouldn't have mattered. But they did argue that she was not, keeping an adequate lookout. There was a question about whether her headlights were on because um, is with most cars now, it's an automatic light. It goes on and off automatically, and it's sort of up to the car to determine if it's dark enough for the headlights to be on. I don't know what the jury actually heard about that, but I saw that in some of the pretrial pleadings. There was also evidence that she may have been on her phone shortly before the crash. I can't tell from the information available whether that evidence was actually admitted to the jury or not. My impression is that it was not, but I'm not entirely sure about that. So the jury awarded total damages of just over $35 million, which I think is sort of a record verdict in Iowa. The crash happened, as I understand it, in Jones County, which is a pretty rural county. Anamosa is the county seat for that. I think Anamosa has like 6,000 people in it. The lawsuit was actually brought in nearby Lynn County, which is Cedar Rapids, much larger area, and I think that they were able to do that probably because the trucking company was based out of Cedar Rapids. Otherwise, you would normally bring the lawsuit where the accident happened. One of the other issues in the case was that the parents, so she was 18 at the time, the parents argued that they were entitled to um, damages for loss of consortium of their adult child. I believe under Iowa law that parents can only seek consortium for loss of consortium of minor children, but not adult children. And the plaintiffs tried to argue that the court should extend that to allow the jury to award damages for loss of their relationship with her. And I believe that court dismissed that on the grounds that there isn't any law to support that. I don't know if there will be or has been any changes to the law on that, but at least that information was not presented to the jury in this case. So according to the plaintiff's attorneys, so the lawyers that actually brought this case, who did a marvelous job for their client, one thing I want to point out here is that two things actually. One is that the verdict was around $35 million, but the jury did find her partially at fault. So the jury found the trucking company slash truck driver 73% at fault and her 27% at fault, which means that the judge then reduced the jury's verdict of $35 million by her 27% comparative fault, which I think leaves a final judgment around $26 million in some change. So that was the final result for her, was $26 million. One thing I think it's really important to point out here for people that might be shocked by this kind of verdict. According to the plaintiff's lawyers, and this is on their website, the insurance company offered $3 million a month before trial and $5 million like a week into the trial. Obviously, they thought they had a good case. They thought they could prove maybe that they weren't even at fault. So the insurance company attempted to settle for much, much less than the um, amount of the verdict. I don't know what the plaintiffs were willing to take, but it may have been less than in the amount of the verdict. But it's really important to understand that when you get these large verdicts, it often there may have been an opportunity for the insurance companies to settle at a much less amount than the verdict, and they chose not to do that and go to trial. But all you might hear is, well, the plaintiff's got this huge verdict. Well, if the insurance company had a chance to settle for less prior to trial, whose fault is that, right? So this was a kind of a record breaking verdict in Iowa. Um, it looks like the trucking company brought motions after verdict to try to get they brought motions after verdict to, number one, have the judge grant them judgment as a matter of law. It also They sought a new trial, and then they asked the judge to reduce her damages. That's called remittiture. And in the briefings that I looked at online, they asked the judge to reduce it to $5 million, on the grounds that if it was invested, it would amount to about 11,400,000 over the course of her life. It looks like the judge denied those motions. I can't tell for sure, and an appeal was filed, but it appears that maybe the parties resolved the case one way or another, and that a satisfaction of judgment was on file. So I can't tell for sure whether the case is still on appeal or not, or whether they just paid the judgment, or maybe settled, which sometimes happens after trial on appeals. The parties reach an agreement. So anyway, so that was a very significant verdict there. I'll put links to that stuff in the description below. Obviously, there may be a lot of um, mixed opinions about this, reactions to this verdict. Um, but feel free to leave a comment below if you have strong feelings one way or another about that. But anyway, I appreciate everyone for watching, and until next time, everyone, have a good one.